So once again, good afternoon, everyone. My name is Felipe Rojas Flores. I'm the president of the Hispanic Law Student Associations. So, bienvenidos. Just want to give a shout out to the International Law Student Association and the Center for Civil Law Studies for helping us organize this and put this event together. And then just a little commercial for HOSA. March 9th at 12:40, we're going to have another guest speaker, international environmental law professor Jimena Nieto Carrasco, who was a former advisor to the Colombian government regarding international environmental treaties. So look out for that. Yeah. Make sure you sign in, and there's food in the back.
Good afternoon, everybody. I have the distinguished honor of actually introducing Santiago Legarre. He actually received his law degree in 1992 and earned a Master's of Studies in Legal Research from Oxford University and a PhD from Universidad de Buenos Aires, which is arguably the better of the two big universities in Argentina. While at Oxford, he wrote a dissertation titled The Historical Background of the Police Power, published in 2007 by the University of Pennsylvania Journal of Constitutional Law. After law school, he clerked for the Argentine Supreme Court. He is now a full professor at Católica Argentina, which teaches constitutional law and writing, but he's currently a visiting professor at Notre Dame University and at Strathmore University in Kenya. We're also blessed with the presence of two distinguished alumni, including Judge Duncan. Thank you for making an appearance, and this guy right here, Chris Handy, who obtained his JD a very long time ago in 2019, and is currently a law clerk at the U.S. District for U.S. District Judge Michael Juneau in the Western District out in Lafayette. So thank you guys so much. I hope you enjoy.
Well, can you guys hear me? Thank you all for coming. Good to see you, Judge Duncan. Judge Duncan, I guess, is kind of technically my boss. It's good to be here again, even though I was sitting in most spots about a year ago. So, you know what that means? That means I'm really young and maybe naive, so take what I say with a grain of salt. But I'm just kidding. Anyway, I guess we'll get started with background kind of on how this paper came to be. A year ago, in the spring of my 3L year, I took Professor Legarre's class. It was comparative constitutional law. It was a short course, and it was really fun. We explored all kinds of things about different, judicial systems around the world, and kind of how stare decisis works here, and how stare decisis works abroad, and the difference between centralized and decentralized systems, as in, of course, that are like the American system with a Supreme Court and lower courts that perform judicial review throughout the system, and places that have a centralized court system that have, say, a constitutional court that has, the sole power to strike down the laws unconstitutional, almost more like a quasi-legislature. But Santiago will tell you more about that when he comes up here. So we had a good time. I think we got dinner and lunch a couple times while he was here, and got to talking. And after the class, he approached me and wanted to write a paper comparing Argentina, the United States, and Louisiana. And at first, I was really, really, really excited, and I'm still really, really excited. But then I started thinking about it. I'm like, wow, man, doing constitutional law, particularly with Louisiana, is going to be difficult because it's a state, small jurisdiction, and uniquely Louisiana constitutional law issues are kind of few and far between, especially as we came to learn in the paper. So with that said, I'll give, a little legal background for the paper. A lot of you probably know through your legal traditions course, or maybe through some other source, that Louisiana has a very interesting legal heritage. The court system, there's kind of, in the beginning, there was this kind of tension between what kind of court system Louisiana was going to have coming from the territorial courts, as it was going to do French and Spanish, and then when the U.S. took it over, and then Louisiana's substantive law, so almost like a substance procedure kind of distinction. And so as we all know, the procedural aspect of Louisiana law and its court system hierarchy is just like anywhere else in the United States. Supreme Court, appellate court, lower courts, just like the federal system. But the substantive law thing was a little more complicated. We kind of turned out to be a mixed jurisdiction, but we have a whole lot of civilian heritage, and then particularly for the topic of our paper, in the context of precedent and judicial review, kind of how do we treat prior court cases. We don't, the heritage of the legal system doesn't actually support stare decisis, and the Louisiana Supreme Court has never really said this is what we have. In fact, we argue that they've said the opposite, that we have jurisprudence constant. And so with that background, we started looking kind of, all right, so we say we have jurisprudence constant. Is that what we really have? Not really. We have, do we have stare decisis? Kind of, but not really. So we started looking around and looking at what the Supreme Court has said, also what other people have written about this, particularly what Professor Legarre wrote about this. He has written quite a bit about the weight of precedent in Louisiana. And we kind of agreed that we're going to start with the premise, with Professor Legarre's premise, that Louisiana kind of has something in between jurisprudence constant and stare decisis, which he calls systemic respect for jurisprudence, which is basically like stare decisis light. It's like we will follow the Supreme Court, and a lot of this has to do with the hierarchy of the court system. The lower courts know who's grading their papers, so they don't want to get reversed most of the time. But as we did a little more research, and we kind of tried to distill what issues were uniquely Louisiana constitutional law issues, we kind of saw that stood, but there were a few cases, and it usually comes down to cases that are like hot political issues. And so I found two cases in particular where we saw lower courts departing from what the Louisiana Supreme Court had to say, which by itself might not be so much of a big deal, but once we got into those opinions and into the reasoning behind why those lower courts did that, we were able to kind of shed light on the fact that we don't really have a full-blown stare decisis like you would say in the U.S. system, in the U.S. federal system. So I believe after isolating things that are uniquely Louisiana constitutional issues, so like, for example, things that would be uniquely Louisiana constitutional issues, as in no overlap or very little overlap with the federal constitution, would be like issues of forced airship, those uniquely Louisiana constitutional law. Some aspects of Louisiana's equivalent to the Fourth Amendment, it's a little broader than what the federal Fourth Amendment is. And just other like Louisiana statutes that have constitutional implications, which brings us to the Third Circuit's dealings with the Medical Malpractice Act. So for those of y'all who don't know, the Louisiana Medical Malpractice Act is the act that gives you the cap on damages when you're suing doctors. And there was, back in the day, a lot of back and forth about the constitutionality of that statute. And the Louisiana Supreme Court had upheld the statute, said it's constitutional, so it's fine. And then the Third Circuit, after that pronouncement, went ahead and said, no, it's unconstitutional, we're striking it down, and this could just be a rogue court. But when we look into kind of the reasoning about that, the Third Circuit was actually very clear in that it said, they're not bound by the Supreme Court. Now, the Supreme Court obviously had feelings about that. But the Third Circuit said, we're not bound. And we actually think they took this up a few years after the Louisiana Supreme Court initially ruled on it. And they said, times have changed. It's time to, consider some new arguments. And, they looked at all the briefs, all the research that was done, and they decided to strike the statute down again. Well, the Supreme Court obviously wasn't too happy about that, and they, reinstated the law as constitutional, and delivered a warning to the Third Circuit that we had seen before. That's like, hey, you should not disobey us. What we say is the law. And so that created not a lot of confusion, but it's kind of contrary to things the Supreme Court has said in the past, such as, we don't have stare decisis, you should follow what we say, but you don't have to. So it's kind of uncertain. But it did look like the Louisiana Supreme Court was kind of taking a stand closer to stare decisis, but it's very clear that, the lower courts, and maybe even some in the legal community in general were like, okay, they said that, but, we still haven't had them adopt stare decisis or overrule all of past jurisprudence that says jurisprudence must on what we have. And then we also found another case. I believe the research was pretty thorough. This might be the only two in the constitutional law context in Louisiana that we've had this sort of friction between lower courts and the Louisiana Supreme Court, which I think is important in this analysis of the weight of precedent, particularly in the context of control group. So in the other case, this was a district court in Orleans Parish. It was still a district court actually. And there was some back and forth about the crimes against nature statute, the Saudi statute. And the Supreme Court had refused to strike it down as unconstitutional. They had said as much, that they were not going to do it. And this case had actually originated in the district court. And they took two cases. They took that case, they took another case at the same time, and they basically, on the other case, they said, we're not going to do it. So now this case basically was remanded to be consistent with that one. The district judge just completely ignored the Supreme Court, said, I'm not bound to follow the Supreme Court. I think this decision is mine, and I don't follow them. It was very blatant. And so then that case went back up to the Supreme Court, and the Supreme Court delivered basically a similar admonishment to what we saw in the medical malpractice case. And so those pretty much are the only two in Louisiana. In the judicial review context, obviously there's others interpreting the civil code and things like that don't have bearing on constitutional law. But those are the ones for judicial review. And so I think that is important because I guess it could be contrasted more with the U.S. system where, Louisiana's got a smaller jurisdiction. The Louisiana Supreme Court can pretty easily, especially in a constitutional law context, since the uniquely Louisiana constitutional issues are so small, can basically review every single one of them if they want to. And so that way they can achieve almost a stare decisis kind of effect pretty easily because, anytime a lower court, which is rare, obviously, with two cases, every time it happens, they can review it and set the record straight, even though we technically don't have stare decisis in the system, but it appears so. The U.S. system, on the other hand, as we all know, has stare decisis. It's pretty well accepted. And we have the whole distinction between vertical and horizontal stare decisis. Vertical stare decisis being your court hierarchy, whereas like a district court bound by a circuit court, bound by the Supreme Court binds them all, sort of thing. And horizontal stare decisis being more of a softer kind of principle, where, say, the Fifth Circuit takes a case similar to one it recently took. Does the Fifth Circuit have to follow what the Fifth Circuit had already said? And that's a much softer obligation, as we explained in the paper. And so, in order to kind of explore kind of what's at play in a federal system, we took a look at the geomedical case, which probably a lot of you are familiar with. And that was the case about admitting privileges for abortion providers. And so we kind of took a look at how that case arose, and then previously there was a Texas case that arose. The laws were pretty similar, and the Fifth Circuit had said that the admitting privileges law was constitutional, and then it went up to the Supreme Court. The Supreme Court said it was not constitutional. And then, so in Louisiana, the same thing happens, but we're in the same circuit. And so the Fifth Circuit takes it up again. And, you know, had the Supreme Court not said anything, you having horizontal stare decisis at play, would the Fifth Circuit have to follow what it said before? Probably not, especially if it found a good reason to depart or distinguish or operate in kind of what we defined as discretionary space, which we think ultimately is what happened the second time. Because the Fifth Circuit, the second time they took up the Louisiana law, was able to do two things. One, factually distinguish the case from the Texas law. And two, they were able to kind of pull some of the more broader principles that the Supreme Court had announced in Planned Parenthood versus Casey, and sort of apply those more broader standards to this, what they perceived as a new set of facts, and come to a different conclusion. Now, we're cert has been granted in that case, but it stayed right now, and we kind of posited that there could have been some stare decisis concerns up at the Supreme Court. It was a close call. I think Chief Justice Roberts was the deciding vote, and you know there's some murmurings that perhaps there were some stare decisis concerns with two inconsistent rulings, or perceivably inconsistent rulings. And so once we see what happens at the Supreme Court level with that case, we'll have and what the Supreme Court has to say about it, what has an idea about how the Supreme Court, whether the Supreme Court is going to take kind of a stare decisis approach, which would technically bind the Fifth Circuit to follow what the Supreme Court has said in the Texas case, or whether they are going to, I mean, they're at the top, so they're going to be operating within horizontal stare decisis, so they'll have a little more flexibility to be able to change their position on that issue. So that's kind of where we're at law-wise for the U.S. and Louisiana. And on those two, we kind of conclude that they're very similar, but mechanically, the reasoning underlying the way the lower courts and the higher courts are handling the precedent aspect is slightly different. So, Santiago, can you talk about Argentina?
Thank you so much. Wow. So, what a joy it is to teach just a 1 month course here and to be able to find someone with whom to write an article and now present. It's like, it's hard to believe for me at least. I've been brought up under the theory that you generally don't give praise to people in their presence, which has a theory with advantages and disadvantages, but I will go by it this time. Regarding my co-author, and you can judge by yourselves too, I'll say that when someone in the class, actually his very good friend, Bill Milburn, and now my friend too, brought up the fact that the June medical case had been decided, then I decided we would discuss in class the two Fifth Circuit decisions and the Supreme Court decision in between them, and this was now part of the class, and it wasn't going to be there, and now it's part of the article too. I also find that nice. Let me take you back in time for a moment as I move on. In the first or second time I came to LSU from Argentina to teach a short course on comparative constitutional law, I had 7 students in my class who were with the law review. And Allison came, then came Durant. She gave me the unpublished version of an article by Mary Alguero, this Loyola law professor mentioned by Chris. And in that article includes a survey of Louisiana judges. And there is a quite famous judge, I forget his name now, who is referenced there saying that in Louisiana, I quote, "there is no such thing as precedent." And I guess that our article is an unintended attempt to prove that he was right and he was wrong. And I think we found quite useful the idea of a spectrum or a range where you would have, this is the number 100, in case you can see it from there, where the level of adherence to past judicial decisions, precedents is max as in the, let's call it, pure common law model of stare decisis, and then here you would have the, there is no such thing as precedent, no such thing, so zero binding force for past decisions. We believe that in real life, in the operation of countries and of states, this doesn't exist, and this also doesn't exist. So the judge couldn't be taken seriously. But then, of course, this is, very relative. The problems with numbers when you're referring to human affairs is that they don't really reflect what's going on. But you would have here at 98, I don't know, Italy or Germany or Spain, where you're really close to, there is nothing, the judge just starts afresh a case and looks at the statute. Then come past judicial decisions by way of declaration in the argument. They don't control, of course, and nothing even close to that. And then you have somewhere along the rainbow, you have Louisiana, but we are placing it much closer to the max of fully fledged stare decisis, both vertical and horizontal, where one past decision, as Goodhart would put it, even though it was rendered in the 14th century, will bind the Commonwealth judge today. Then you maybe here have the USA, by which I mean, or we mean, the federal judiciary and the judicial systems of 49 states, which operate similarly regarding precedent to the federal system. And then you have jurisprudence constant here, and what Mary Alguero calls systemic respect for jurisprudence in Louisiana, where you do have a notion of precedent, although it's clearly not this one. But then these judges, they are part of a common law country. Although they live in a common law state, they have been trained with not only civil law, but also common law methodologies. And furthermore, as Heidi Thompson, who teaches here, told me the other day, some of these judges who sit in Clinton, Louisiana, we have here 2 parishioners from Clinton, they will hear both civil and criminal cases, and then they'll have a civil law approach to the former and a common law approach to the latter. Then here you have my dear country, Argentina. So if Louisiana is a civil law state in a common law nation, Argentina is in a continent, South America, where every other country is a civil law country. And so is Argentina, except that our judiciary was molded after the US one, and our Supreme Court and our courts of appeals from 1856 onwards, they imitated the methods and the practices of the US courts, including deference to precedent, without buying stare decisis 100% or even 98%. So what they have is something that sometimes goes under the name of soft obligation, where the Court of Appeals will be in principle bound by Supreme Court precedent. But this principle has an exception, and the exception is when the Court of Appeals finds that in the past precedent, the Supreme Court of Argentina overlooked a very relevant argument for this case that now has been brought for the consideration of the Court of Appeals in this new case. In such a situation, in effect, the Court of Appeals is allowed to overrule the Supreme Court from below. This is the so-called new reasons doctrine. Then the case will eventually go to the Supreme Court, and the Supreme Court, if the reasons were indeed new, and this wasn't a rationalization or a lie, they will never overturn that decision on stare decisis grounds. They will never say, this is wrong because it departed higher case law. No, they will inspect the merits of that overruling from below decision. So this is the so-called soft obligation doctrine. And in our paper we argue, but we are quite tentative about this, that this doctrine is closer to the pure civil law model, and that jurisprudence constant plus the systemic respect for jurisprudence is closer to the common law model. But one could not argue the other way around. You know how these things are. It depends on what you're looking at. Because for Argentina, one case of the Supreme Court is enough for there to be a soft precedent. Whereas under some theories in Louisiana, you actually need a line. This is what jurisprudence constant is about. On the other hand, in theory, the Court of Appeals, the State Court of Appeals in Louisiana, in theory, is not allowed to depart from higher Louisiana Supreme Court law, arguing there are new reasons here. But my colleagues at the law school here tell me that that's exactly what they do when they want to depart. They will say they're distinguishing, they're making factual differences and using common law tools, but in effect what's going on is that they're unhappy about this precedent and they want the Supreme Court to reconsider, and Chris already made reference to a couple of cases in Louisiana constitutional law that have to do with this, but there are many that have to do with the civil code as well. We have in the audience Julio Romaniach, a big expert, who might enlighten us during the Q&A, which is about to happen as I am about to finish. I just want to thank you all again for your presence here, and thank the two student groups that have hosted the talk again, and as well the Civil Law Center and Professor Moroto, who is as if he were present today, although he's in France. I mean, France is all over the place here. And whatever you don't like about the system, France is to blame. So thank you very much, and if you would like Chris to join me here, we are happy to eat or to take your questions or both. Yes, by the way, the first question is by the father of one of my students, John Cook. He's David Cook, the father, and I'm so delighted that he drove all the way from Lafayette under the rain to come and listen to us. Thank you so much. It's an honor.
Thank you. It's my pleasure to be here. An idea for the next paper. I'm guessing that the paper did not address the possibility of the changing makeup of the courts. For instance, when the Third Circuit had last ruled on the Medical Malpractice Act being unconstitutional, as I recall, Judge Genovese was on the Third Circuit. Judge Genovese is now on the Supreme Court, and I think that it injects a little bit of uncertainty, perhaps predictability, to the system, and of course that would involve a lot more research. But I'm just wondering whether at some point that might be an interesting study to find out the effect of the change in makeup of the court on whether or not these precedents are followed.
Would you like to take this one?
Yeah, I mean, that's you're absolutely right. That is true.
That's awesome, because I'm going to say you're absolutely wrong, so you go first.
No, I mean that Judge.
No, now you need to stick to your.
I mean that Judge Hernandez is on the court now.
Oh, no, that's a fact.
That's a fact.
Of course he's right.
But, yeah, the paper yet doesn't really get into that. But, I mean, I guess it could. I mean, the more, I guess, civilian-minded people on the Supreme Court, the less likely, I guess, they are to say things like they have, like, you must follow what you do. And so,
Well, I think if I understood the question, it has more to do with the fact, or the question, to what extent do changes have to do with new personnel? And I think my answer to that would be that when you're closer to this part of the world, the change of personnel, like in Argentina, is absolutely relevant. And here, in theory, it should be irrelevant. So when the Supreme Court decides in June, this case, June Medical, you know, it shouldn't make a difference that Justice Kavanaugh is now in the court when you think of vertical stare decisis. Now, when it comes to horizontal stare decisis at the Supreme Court level, of course, when they put you in the Supreme Court, they put you there to say what you think, and they will expect you to overturn Roe v. Wade or whatever it is, right? But at the vertical level, under strict common law fashion, it doesn't matter who is in the court. So now I am in the Supreme Court, but I don't exist as a person. What's the precedent of my court? Now, this is Louisiana, so for sure it will matter. Imagine if there's a judge who says, there is no such thing as precedent, I am the law. So if I am a new am, then of course it will make a great difference. Yes, thank you.
We actually studied at Universidad de los Andes, and one of the things that we found most peculiar about the Colombian system was their use of like a separate constitutional court that gave advisory opinions. So my question is, considering that is a civil law jurisdiction, do you think that advisory opinions have an effect on precedent? Obviously, here in the United States, we don't have advisory opinions.
So nor do we in Argentina. One of the reasons we did this together is that Argentina, unlike Colombia or Chile, has a decentralized system like the US without a constitutional tribunal. So it would be for you, when we have coffee later, to enlighten me. I wouldn't be able to tell you what's the precedential value for the normal courts of what the Constitutional Tribunal says. Yes?
So, I appreciate your talk. I want to nuance something that was said about what you're calling horizontal stare decisis. On my court, which is the U.S. Fifth Circuit, we hear cases, of course, in panels of 3. And the idea is that when a panel hears a case, we are an agent of the entire court, which is 16 or 17 active judges. So a panel of the court has no authority whatsoever to depart from a prior panel decision. 0. And if I even ever suggested the contrary, my colleagues would ostracize me. So there is no soft horizontal stare decisis with respect to panel decisions on the court. We are bound. The only way you can depart from a panel decision is to go en banc, which we do 3 times a year. But we are bound. And as a matter of terminology, although of course you're scholars of the subject, and so you may well be correct that, you probably are, that one refers to this as a question of horizontal stare decisis. We just say, we call it the rule of orderliness, that one panel cannot overrule a prior panel, and it's in our case law. It's called the rule of orderliness. And that's the way that we think about it on the Fifth Circuit.
Thank you, Judge Duncan. Would you like to comment on that?
I mean, yeah, that's actually really good. You might have to add that in the paper. Yeah, I guess I didn't really think about the whole, I mean, that's the en banc. When the court sits an en banc, yeah, they can do themselves, but yeah, I didn't think about the panel thing.
Yeah, and you can verify that because it's a matter of precedent that one panel of the court has no authority to overrule a subsequent panel.
Yeah.
But how about a decision of a panel of your circuit with regard to a relevant precedent of a panel of a different circuit? Maybe this is what he had in mind when he said there is no horizontal obligation there, only.
You mean from circuit to circuit?
Yeah, from circuit to circuit.
Oh, no.
Yeah, because that's another nuance too.
And
that
that's,
didn't
we have
discuss.
no obligation to follow another circuit.
Right.
Now, we have a prudential obligation
Attention.
Right.
to consider what other circuits do. And why is it prudential? Because if there's a circuit split, then that creates the circumstances for Supreme Court review by certiorari. Let me draw another nuance. So, because I did this the other day, so I wouldn't want you to think that I violated the rules of my court. We issued a decision 3 days ago in a First Amendment case that recognized that a prior precedent of our court, prior panel decision, had been abrogated by the United States Supreme Court in the intervening time. Now, precedent of my court allows a panel to recognize, provided that the abrogation is crystal clear, that a prior panel has been abrogated. Now, there's still the time for my court to take my decision on banc, so maybe I'll find out that I was too hasty. I don't think so, but we'll find out. But it's a pretty big case, and the panel was unanimous, and I think it's correct. But I did not have an obligation to follow the prior panel because the Supreme Court, in the intervening time, had abrogated the reason for that.
You said that the expression stare decisis is normally not so much used to refer to that horizontal level and offered us the more usual one. How about when we are at the Supreme Court level and there are no panels, of course, would you still not
Yes.
use the
No,
expression?
the Supreme Court uses that expression to refer to its prudential obligation. It's not is it an obligation? The Supreme Court refers to that, as you know, as part of its obligation to follow its own precedent. But obviously, it is not binding on the court itself. I mean, it's a rule of prudence. It's as I understand it, it is fairly strong, very strong when it comes to statutory questions.
Less strong.
Why? Because Congress can come in and
Yeah.
correct.
Yeah.
But on a constitutional question, I mean, look at what Justice Thomas has written recently. He's not in the center of the court on that issue. But Justice Thomas has written, the decision is clearly wrong, the court ought to just overrule it. So,
Yeah, thanks, that's very helpful. Julio, was that a hand?
No.
Well, what a pity.
Yeah, and piggybacking off of that, I think that is something that we do observe as a whole in the paper, is on those questions of like purely constitutional issues, particularly ones that are very policy oriented, that Congress is not dealing with, or the legislature is not dealing with, that's when you're most likely to see either form of stare decisis really start to break down. But particularly in the federal system, at the U.S. Supreme Court, horizontal stare decisis becomes much more complex.
just another terminological thing. Again, you may obviously be correct about this, but when I'm thinking of my obligation to follow United States Supreme Court precedent, which is, of course, is non-negotiable, we just follow it. We don't talk in terms of stare decisis. We talk in terms of, well, we're bound by the decisions of the Supreme Court. Full stop.
Do you ever talk about stare decisis in your court?
Not really.
Not really.
Not really. I
So-
mean, I suppose if we were en banc and we were deciding whether to overrule a precedent, which we do and have done, we might think about some of the concerns surrounding stare decisis. But and I haven't been on the court that long, but I just don't see that as a norm on the court.
It's very interesting. Thank you for that. Thank you. Yes.
Just out of curiosity, what is the effect, you may not have looked at this because it looks like you're looking at very specific jurisdictions, but what are the effect of like because they say that there's a common law and civil law, and then there's certain mixed jurisdictions. I'm trying to think of one, I think Madagascar is one. What do you think the effect of having that mixed jurisdiction is on stare decisis?
I mean, I have a thought about Louisiana. We don't really get into it in the paper. I have a personal thought about it. But, I mean, I think mixed jurisdictions, depending on what kind of influence it is, so if it's like, if it's got a civil law heritage, like Louisiana has a civil law heritage, but it's in a common law state, you're going to get her out. you're gonna get a lot of that common law influence coming in, especially with it being loan. But I think the exact nature of it, of how mixed it is also important. So like in Louisiana, really the general distinction is like private law in Louisiana is very civil oriented, and then public law is very common law oriented. And so public law would be like criminal law, even constitutional law. And there's actually a great article out there that suggests that you can explain and justify the way the Supreme Court acts with these constitutional cases that we're talking about versus its civil code interpretation cases. That under public law, because we're common law public law common law influence, that you would be more like stare decisis binding, whatever, in that area, and more jurisprudence law in the private law civil code area. So yeah, I think the jurisdiction could take influence of what tradition is influencing what areas of the law. That makes sense. Could affect how it treats precedent in those different areas of the law. Yeah, that's just me.
Yep, no, this is your concurring opinion. And on that note, if the organizers agree, we would call it a day, as some students need to go to other classes.
Yeah, we have about 4 minutes left before we really have to get this going. But
Yeah.
did you guys want to like offer your contact information just in case anybody has any
Sure,
questions
sure.
or anything like that?
We write them on the board.
Thank you guys so much for coming. If you could do us a favor of at least signing in, it really does help with our food budget, and it does allow us to show the administration that we do have people coming to these events, and we can have more of them. Like Felipe mentioned before, we have a very similar event on March 9th, where we have the lead negotiator for the Colombia's environmental team at the UN doing a similar talk on some of the stuff that she's been working on. If y'all have any interest in that, we urge you to come to that as well.
Thank you very much. Thank you very much.